Woodley East, page 8.
Page 8, second paragraph. Is Central Badibu. Badibu is missing. Central Badibu. Yes. And the other corrections continue.
Noted, huh? Page 9, page 8. Yes, honorable member for Fatou.
Question put and agreed to. Those in favor, please say aye. Instead of ayes, S should be omitted. And if you go down, second to last paragraph is the same.
Noted. Any other honorable member? Observation? Correction? We go to page 9. Page 9, please. Lower Fatou West.
The fifth paragraph. The Honorable Member for Kantora, on behalf of the Joint Committee, S should be omitted. Table the report for consideration. D should be omitted out. And adoption by the Assembly. Thank you.
Thank you. Noted, honorable member. Any other observation on page 9? Then we go to page 10. Page 10. Page 11. Page 10. Yes.
Page 10, the same mistake is continuing from page 9. Those in favor, please say aye. S should be omitted.
Taking note of that. What of page 11? Page 11. Page 12. Page 13. Honorable member for Basse, page 13.
Honorable Speaker, thank you. Paragraph, the Honorable Member for Central Badibu table his motion, his report. I think it should be the report of the Joint Committee. And again, the committees here, they are all current S. I think you pay attention to that also.
Honorable member for Sanimentary, understand you?
No, it's all right.
It's all right, okay. Honorable member for Fatou West, Upper Fatou West.
The fifth paragraph, after the committees on page 13, these should be omitted for consideration and adoption by the Assembly.
Thank you. Noted. Page 14. Page 14. Honorable member for Woodley East.
Yes, page 14, last paragraph, V, the first line. I believe since you are mentioning the name of the committee for the first time, we put the full name there. We add NGO Affairs and Sustainable Development to the name.
Noted. Any other observation on page 14? Page 15. Honorable member for Basse.
Mr. Speaker, paragraph 3, paragraph 3, the second line, table the report of the committee. It should be 1F. For the consideration that this will go off, and after motion to sit beyond 6 o'clock, standing order 11.1, the honorable member for Brikama South move that the assembly sit, not sits, it's infinitive, beyond 6 o'clock. Thank you.
Noted. Honorable member for Woodley East.
Yes, the same paragraph is mentioned in the first line. The chairperson of the select committee, not committees.
Noted. Honorable member for Kantora.
It's the same observation.
Thank you. Honorable member for Basse.
Mr. Speaker, this is a consultation for consistent purpose. The last sentence. Those in favor. Okay, after that, you have the Constitution was unanimously ratified. Which Constitution? Here, I think we are referring to the Constitution of the African Ministerial Conference on Meteorology. So, are you going to maintain that, or are you going to leave it like this? It's a consultation. The last word.
Noted. Noted. Page 17. Yes, Woodley East.
17, collection put and agreed to first line. The assembly do stand. We remove the S.
Thank you. Any other observation, correction? That is page 17. Yeah. Thank you. Okay. Honorable member for Basse.
Mr. Speaker, grammatical problem.
On page 17.
Page 17, be it resolved that this August assembly do stand. I think the S will go off. Oh, you did that correction. Okay, thank you very much. I was not paying attention.
Yeah. Sanementary, yes. On page 17.
Yeah, no, let me take you back to page 15. Motion to sit beyond. We are dealing with
Honorable member, please. You said page what?
page 15.
You want to take us back to page 15?
Yes.
No. I said no. Please. No. Sit down. Please, silent. Honorable members, please. It has been moved and seconded that the records of votes and proceeding of the National Assembly sitting of Thursday, 9th July 2020 be approved with amendments. Those in favor, please say aye. Aye. Those not in favor, please say no. The ayes have it. Clerk, can you proceed, please?
Personal explanation, Standing Order 50 by the Honourable Member for Banjul North.
Honourable members, in accordance with Standing Order 50, the Office of the Speaker received a notice from the Honourable Member for Banjul North requesting to make a personal explanation in accordance with the Standing Order 50. The text of the statement was reviewed, vetted accordingly. I have granted the approval for the honorable member to make a brief statement as per approved text. Before giving the honorable member the floor, I wish to draw the attention to the Standing Order 50, 2 in bracket and 5 in bracket. Finally, Standing Order 50, 6 in bracket states, no member shall permit to ask question at the conclusion of the personal explanation, nor shall any debate be arise. So, then, honorable member for Banjul North, since permission is granted, you can go ahead.
Thank you very much, Honorable Speaker. Honorable Speaker, this is a statement of public interest to pay tribute to the frontline workers in the fight against COVID-19 pandemic in the Gambia. Honorable Speaker, the COVID-19 disease entered the shores of the Gambia when the first confirmed positive case of infection was registered at a health facility on the 17th of March 2020, which unfortunately turned out to be fatal. Since this first case, and until recently, the country had been registering positive cases requiring hospitalization and treatment. It was initially projected that Gambia will experience a surge or peak of significant increase in COVID-19 infections around the end of June this year, and which was later shifted to the end of this month of July. Honorable Speaker, there are indications of the increase in the rate and frequency of infections. Not only are we registering more positive cases of COVID-19 infections, but also a rise in the death toll, now numbering 3. The country has now started registering local or community transmission where the source of infection is not known. Considering the highly infectious nature of the COVID-19 disease, the healthcare workers who are in the front line at the health facilities, screening, tracing, testing, and overseeing treatment centers are exposed to infection during the course of their work in responding to the pandemic. It is a national tragedy that the Gambia had to lose 3 precious lives, with the third and most recent being a healthcare worker who also succumbed to COVID-19 in the line of duty a few days ago. Honorable Speaker, as a sign of respect and recognition for his service to people as a healthcare worker, I would request on behalf of our Select Committee on Health that you invite the National Assembly members to observe 1 minute of silence in honor of this fallen hero, the late Mausise. This gesture is to remind Gambians that COVID-19 is a killer that requires the strict observation of WHO takeaways of physical distancing, hand washing or sanitization, and face masks aimed at defense against the illness and to prevent transmission, and to also further demonstrate that the lawmakers of this country have recognized and acknowledged the role and invaluable work of healthcare personnel as lifesavers who are even sacrificing their lives for others to live. On this note, Honorable Speaker, I beg to take my seat.
Thank you, Honorable Member. Honorable members, may we raise to observe 1 minute silence in honor of the late health worker who died as a result of COVID-19. May we rest. Thank you, honorable members. Please be seated. Thank you, honorable members. May the departed soul rest in perfect peace. Clerk, you may proceed to the next item. On the
Bills. Standing Order 70 and 73, Committee of the Whole Assembly on the Local Government Amendment Bill 2020 by the Honorable Member for Lower Badibu.
Point of order.
Point of order. Honorable Member for Upper Fatou.
Thank you, Mr. Speaker.
Based on standing order.
Standing Order 63, 2 and 3. 63, 2 and 63, 3. It has been brought to my attention, Honorable Speaker, that this particular bill has not fulfilled the obligatory requirements of processes that it should, in fact, not be entertained in the House. The simple reason is Section 63(2) says that if a bill is a member's bill, then in addition to and contemporaneously with the provisions in paragraph 1, a statement of the general nature and objects of the bill shall be published in at least one newspaper circulating in the Gambia. Number 2, the second one is 63(3). If the bill contains a clause or clauses intended to affect or benefit some particular person, association, or corporate body, then, in addition to the provisions in paragraph 1, such bills shall contain a clause saving the rights of the President of the Republic and successors in office, all bodies politic and corporate, and all others except those as are mentioned in the bill and those claiming by, from, or under them. So you will see that basically, we also the reasons and objects of the bill. It's claiming to give the councils or councillors the independence from their political parties and leaders. And Section 63(3) is basically trying to address that. Anybody affected in favor or adverse should actually contain a clause saving the rights of those particular persons or bodies. Thank you, Mr. Speaker.
Honorable Member for Upper Fatou, Standing Order 63(2) bill has been met as I was made to understand. It has been published. Wait, look, please, anybody who make noise, beating the table really, I think you have to wait until the statement is concluded. Please. I understand it has been published in the 3 newspaper, Gambian newspaper, that Section Yeah. The file before me, it was on the 26th of June, 2020, and it was published in the Point newspaper, Standard newspaper, Fourier newspaper. So, then he said what?
This one regarding this one.
Honorable members, Honorable Member for Fatou, this bill cannot be retractive. As a result, it will not favor or it will not affect any person's rights. Retractive. So, as a result,
Honorable Speaker.
Honorable Speaker, point of order.
Sorry, let me just finish.
No.
Honorable Speaker, now, can you please read for the Assembly, Section 63(3) and understand what is involved in there, and then that way you'll be much advised.
Honorable Member, I think according to the file, I've made the pronouncement that 3 newspapers, this thing has been published in the
No, it's not that, Honorable.
That's addressed.
Yes.
That of order, Honorable Speaker.
That is addressed by 63(2). I agree, and I will double check on that. Thank you very much for that.
Honorable Speaker.
However, 63(3) does not only
point of order, Honorable Speaker.
Mention persons, but it also mention corporate bodies. Wait, what are you doing?
Honorable Member, the bill hasn't got, will not retract the right of anybody.
No.
So, as a result, really, I saw Honorable Member nominated Yakumba Jaite. What is your point of order?
Thank you. Honorable Member, Honorable Speaker, I'm just rising on point of order 32(1)(a). It says, by raising a question on a point of order where the proper procedures have been followed. The decision whether this bill would affect the right of political bodies, corporate bodies, or political or association, it would be one quite subjective. And I would advise the Honorable Speaker to actually seek legal interpretation of this provision, because it is very
Honorable
technical.
Speaker, point of order. Point of order.
I am rising on a point of order. If I complete my point.
Honorable Speaker, point of order. Yes.
I am rising on a point of order.
I am also saying what is being said. There is a point of order. What that statement itself, I am objecting. It's a point of order. Honorable Speaker, I want to rise to a point of order.
Honorable Speaker, your mic, please.
Honorable Member for Serakunda, a note has been taken on your point of order, but allow her to complete her statement, and then you will be called upon, please.
Honorable Speaker, it's a point of order by virtue of the statement. But it's left to you. I'll accept your ruling.
Yes, Honorable Member for nominated member, please, you can continue.
Thank you. Honorable Speaker, if you...
Honorable Speaker, they are saying a point of order on the statement.
I think, Honorable Speaker, you've made a ruling on...
There is a point of order on a statement. You cannot allow to proceed. What is a point of order?
It is your discussion.
Honorable Member for Kantora, Honorable Member for Kantora, I have made a ruling for nominated member to continue. Please, don't disturb the proceeding of the House. Thank you. Honorable nominated member Yakumba Jaite, please.
Honorable Speaker, it is obvious that these standing orders are new and probably being tested during this session for the first time. And I would refer you to section 63.3, and it reads, if the bill contains a clause or clauses intended to affect or benefit some particular person, association, or corporate body, then in addition to the provisions in paragraph 1, such bill shall contain a clause saving the rights of the President of the Republic and successors in office, all bodies politic and corporate, and all others except those as are mentioned in the bill and those claiming by form or under them. Honorable Speaker, the bill in question, it's clearly affecting the rights of political parties. And the bill in question clearly does not contain a saving clause in regards to those rights. Honorable Speaker.
Okay.
Point of order.
Silent, please.
No, let them make the noise. It wouldn't distract me. Honorable Speaker, this section is not saying whether the bill would have a retroactive effect or retrospective effect or not. It says if the bill shall affect or is likely to affect or intended to affect, it shall, it's a mandatory, it shall contain. It does not matter whether the bill will have a retroactive effect or retrospective effect. There must be a savings clause in the bill. This is a matter of reading and a matter of interpretation, and this is my interpretation as it stands. And I would advise that we suspend this sitting, get an interpretation on this until we are clear, because this is a mandatory provision of this standing orders which has never been tested, and it is a shall. Thank you, Honorable.
Point of clarification, Honorable Speaker.
Observation. Observation, please. Observation, please. Honorable Speaker. Observation, please.
Yes, I'm coming to Serakunda, please. Honorable member for Woodley West.
Honorable Speaker, whilst respecting the motion which is put without even being seconded, and there is continuation of a debate on it, but because we must respect the deep concerns of people, Honorable Speaker, we are departing from procedure, which is Standing Order 66, which tells us the stages of the bill. Honorable Speaker, we cannot lecture people on procedure when we are departing from procedure. So and really, Honorable Speaker, I'm alone. I have no support. I'm seeking no support in what I'm saying in this Parliament. Honorable Speaker, the procedure is for us to have a motion seconded before you even talk about the debate. And Honorable Speaker, you, the Speaker, you are the authority. And there is permissible interruption. And you are speaking and somebody interrupted you, Honorable Speaker, and we still remain calm. Honorable Speaker, I don't need to give a lecture. Please, Honorable Speaker, take charge, and then let's move according to procedure.
Point of order, Honorable Speaker.
No. Honorable nominated member, please. Please, I want to make a ruling on this issue, please.
Okay, Honorable Speaker, before you make a ruling, may I just rise on a point of order on this matter? Because this is, I think what is done is right. And
Point of observation, Madam Mr. Speaker. Mr. Speaker, we must respect the procedure. Cannot allow somebody to go ahead when
point of order.
He or her an authority.
Honorable Speaker,
Honorable nominated member, please sit down.
Point of order.
Honorable Speaker, you have to give her the floor first.
Please sit down.
Point of order. Point of order. Point of order. The point of order.
Come rain, come sunshine, this bill will go.
Point of order.
Honorable nominated members, point of order. There was no ruling on it, and as a result, we will make a ruling on that. We cannot take a point of order upon point of order. So we want to make a ruling because Honorable Woodley West raised his card. Honorable Brikama North also is asking point of order. But I think to be in line, we have to make a ruling on this one, as I am advised, before any other point of order, please. And yes. No. Honorable members, this bill does not affect any particular person, corporate body, or association. As such, I now make a ruling that we proceed to the next stage of debate today.
Mr. Speaker, there is a motion on the floor. There is a motion on the floor. No? You said you were going to go according to procedures. Please, do that and finish the procedures before you can actually rule. Yeah? The motion was not seconded. It was not seconded.
We said the motion was not. Honorable members, have ruled on point of order, then we move to the next stage. Thank you. Honorable members, in accordance with Standing Order 50, Honorable members will recall that Local Government Amendment Bill 2020 was committed to a committee of the whole House by the Assembly Business Committee for consideration stage. Accordingly, in accordance with Standing Order 66, 2 in bracket, B in bracket, I in bracket, the committee stage on the said bill is scheduled for today. During the consideration stage, honorable members shall have the opportunity to give detailed consideration and scrutinize to every clause scheduled in the bill. This stage also provides the first opportunity for the amendment to the bill to be debated and vote on. I will now therefore resolve the Honorable Assembly into Committee of the whole House to give consideration of the said bill. Sorry, this is Honorable members, the Assembly will now go into the Committee of the whole House to consider the Local Government Amendment Bill clause by clause, and will be guided by the Standing Orders 70 and 71 during the consideration stage. Thank you. Clerk.
Clause 1, subtitle.
Honorable members, it is proposed that Clause 1 stands part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. So what are we going to do? Honorable members, it appears that ayes have it. So, no. If you are not satisfied, well, we go into vote. But that should not be. I don't think we should go to that stage now, because voting will come maybe by Friday or so. Yes, I think voting will come maybe by Friday or so. So I don't think there is any need of. There is no need. The voting will. The actual voting is coming up on Friday for the third reading. Yes. Can I allow the
Honorable Speaker?
But is that a point of order or?
Yes, I'm just making an observation that you are the one who must listen, and what you rule is what stands, Honorable Speaker.
These are the ruling anyway. Honorable members, clause 1 now stand part of the bill.
Clause 2, amendment of CAP 3301.
Honorable members, it is proposed that clause 2, amendment of CAP 3301 stand part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it.
Clause 3, amendment of section 19.
Honorable members, it is proposed that clause 3 stand part of the bill. Amendment of section 19 stand part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. Ayes have it. Honorable members, it will be recalled that there was a suggestion to amend the objects and the reasons of the bill. Can the honorable member who made that suggestion can come up with the amendment?
Honorable Chair, apparently standing order 64(3) state that the memorandum of objects and reasons shall be updated to reflect any amendments made during the passage of the bill, and an updated memorandum of objects and reasons shall be made available to members prior to the third reading for any bill amended during its passage. Honorable Speakers, if we look at the process to have included the second reading and the debate, I did point out that the objects which says this bill seeks to grant independence to the members of the area council from their respective parties and political leaders, and to further, so we should delete all that. The bill seeks to grant independence to the members of the area councils, full stop. It further seeks to enhance the system of local government autonomy, freedom of speech and debate in accordance with Section 193 of the Constitution of the Republic of the Gambia. The bill, the second paragraph, the bill also seeks to ensure that council members' sense of duty, functions, and actions are influenced by the supreme national and community interests and the dictates of conscience, full stop. Then we delete the rest. This is my proposal, Honorable Speaker.
Honorable Speaker, just to follow the procedures and see clarity, if you look at the amendments on the section 73, it states amendment proposed to a bill at committee stage. in committee of the whole assembly shall be notified in writing to the table clerk. The deadline for notifying amendments proposed to a bill in a committee stage in the committee of the whole assembly is 4 p.m. on the day before the day appointed for the commencement of a committee stage. 4. Any proposed amendments to a bill at a committee stage in the committee of the whole assembly, notice of which has not been given, shall be handed to the clerk in writing. So I think that's the procedure we need to follow.
Point of procedure, please.
If there
Point of
are
procedure,
any amendments to be made, I'll be guided by the office
Point of procedure,
on this
please.
issue.
Observation, Honorable
Please,
Chair.
Honorable Speaker, point of,
There is no point of observation.
point of procedure.
There is no point of procedure. Please, Honorable Member Kantora, please don't interrupt the House. Thank you. Please. Yes, Honorable Member, Honorable Nominated Member, yes? Do you finish?
Yes.
You finish? Yes. Okay.
We'll come back to her.
Okay. The clerk will come back to you. Oh, sorry, I will come back to you with the consultation with the clerk. I will come back onto you. Yes.
Honorable Chair, the objects and reasons do not really have much significance as far as the act is concerned. So essentially, what is being recommended can in fact be done by the mover before the third reading, that is to actually amend these objects and reasons and put it before us for the final vote. So what is strongly recommended in the spirit of the House, that this is not directed to deal with any issue on the ground. I don't know other members, but I'm not aware of any issue that has moved me to support this bill. And I doubt whether passing this will have any impact on anything that is on the ground. I think that is a matter left to the Supreme Court. So, Honorable Speaker, you may rule, you may decide that the mover will do the change of the reasons for the third reading.
Honorable Speaker, point of order.
Honorable Speaker, if I may, also I would like to refer you to section 71, which states a committee of the whole assembly to which a bill is committed for committee stage shall not even discuss the principles of the bill, but only its details.
Honorable Chair, point of order. Point of order.
Honorable Chair.
Honorable Member, you have already made your point. Please,
Honorable Chair.
Please.
Honorable Chair, I'm not stopping. Honorable Chair, you cannot just pick up and speak without the chair giving you permission. That's the procedure.
I think I asked clearly for the chair's permission. It's not for you to decide whether the chair has given permission or not.
No members will be allowed to speak like that. You have to control the House.
In fact, that's what you are doing. Madam Speaker, are you going to be subjected to the observations of people like that?
I am not taking dictate from any other person, please. I am guided by the technical officers here. So what my situation is that I need to listen to them. Thereafter, then I made a decision. But I am not being dictated to anybody, Honorable Member. Please.
Ilyasa Not, sit down, please.
We are only making amendment to details.
Which is the
Honorable members, we are only making amendment to the clauses and schedule of the bill. Now, the person in charge, as you rightly mentioned, may make amendment before the third reading of the third reading, before the third reading of the objects and reasons of the bill. Please. Then we can move ahead.
First, to the point of order, you just read.
Please, honorable nominated member, please, I think I've given you the opportunity that what you said is in line. It's in line, but at the same time, it applies to the clauses and the schedule, not object and reasons. And I think everybody in this assembly heard you very well, and I think a note will be taken. The person who comes with this amendment bill will certainly look into that. If he fails to, when he comes back, the House has a right to reject the bill completely. Yes.
Honorable Speaker, point of order. Honorable Speaker, point of order.
Honorable member for Central Badibu.
I'm rising on point of order, please.
Honorable member for Central Badibu, with due respect, I think
I'm rising on point of order.
Honorable Speaker.
Point of order, please.
No, honorable member for Central Badibu, I think...
it's a different point of order. I have point of order, please.
If it is a point of order on this matter, I think...
Mr. Speaker, can you allow me to be enlightened? It's my right, please.
Okay,
we want matters to be cleared out. Please. I'm not making any distraction. Standing order 70, clause D.
Okay, you can go ahead.
2E. 70, check 70. There is E, please. I'm not there to show it to you. Amendments proposed to an amendment shall be dealt with before a decision is taken on the original amendment.
Okay, thank you. There is no amendment yet admissible. Okay, there is no amendment yet.
There is a proposed amendment.
It was a proposed amendment.
Yes.
And it's not accepted as yet.
I want to be enlightened. It's just a matter of clarification.
Please, honorable member, please allow us to resume the assembly, please. Thank you. Look.
Hit the hammer and move.
The assembly now resumes.
When he moves, then we will ask for a second, then we put the question. Just for the report what transpired. Then we will adjourn the assembly now.
Honorable members, the assembly now resumes. I now invite the person in charge of the bill to move the report of the Committee of the whole House.
Thank you very much, Honorable Speaker. Thank you, Honorable colleagues. Honorable Speaker, I report that the bill entitled the Local Government Amendment Bill 2020, having gone through the Committee of the Whole Assembly with amendments, be adopted and the report be adopted as the consideration stage with amendment.
It is without amendment.
It is without
No
amendment. No amendment is done on the bill yet.
Without amendment, yes.
Without amendment. Thank you. Any seconder? Latakunda Sabiji.
Thank you, Honorable Speaker. I rise to second the motion.
Then I'll come to this one. Here.
Is it a motion?
Silent, please, please, one meeting. It has been seconded, eh? It has been moved and seconded that the bill entitled to the Local Government Amendment Bill 2020, having been reported to have gone through the Committee of the whole House with amendment, without amendment, be adopted and report be adopted as considered in the committee stage. Those in favor, please say aye.
Aye.
Those not in favor, please say no.
No.
The ayes have it. The third reading will be scheduled when?
Read this. Because now the ABC will meet and do that, but most likely Friday.
Honorable members, the third reading of the bill entitled to the Local Government Amendment Bill 2020 will now be scheduled by the Assembly Business Committee after 3 clear working days for the member for Lower Badibu to move for the third reading. However, before this date, the Office of the Clerk is hereby urged to ensure that the amendments to it's here.
You thought that they are final version. You can just say the final version.
No, come. Because this, I mean, the final version of the bill. Honorable members, the final version of the bill is printed and circulated to the honorable members in advance. I thank you all.
Honorable Speaker.
Which one? Clerk.
Point of order, Honorable Speaker.
Clerk. Next stage.
Bills. Standing Order 66, second reading of the Criminal Offences Bill 2020 by the Honorable Attorney General and Minister for Justice.
Honorable members will recall that the first reading of the Criminal Offences Bill 2020 was done on Monday, the 22nd June 2020, and today is the appointed second reading in accordance with the Standing Order 66-2 in bracket. Therefore, pursuant to Clause 67 of the Standing Order, I now invite the Honorable Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled to Criminal Offence Bill 2020. Honorable Attorney General, Minister of Justice.
Thank you very much, Honorable Speaker. Honorable Speaker, I wish to move that a bill entitled Criminal Offences Bill 2020 be read a second time. Thank you.
Thank you very much, Honorable Minister. It have been moved. Any seconder? Any seconder? Honorable Member for Jimara.
Thank you very much. I rise to second the motion.
Thank you. In accordance with Clause 67(1) in bracket of the Standing Order, I will now open the floor for the debate on the general merit and principle of the bill. Any honorable member who wishes to take part in the debate may do so by raising your constituency card. Honorable Member for Banjul South, the floor is yours. On the merit and general principle of the bill.
Thank you very much, Honorable Speaker. I think this bill is very much welcome because the provisions under the bill have been with us since 1933, and we all know that they are outdated, because we live in a democratic world now, and what was termed illegal then.
Sorry, Honorable Member, for interruption. Can those who want to take part in the debate can raise their flag up, please, so that they can take record of them. Take note of all the cards. Huh?
Proceed.
Yeah, you've taken all? Okay. Honorable Member, you can go ahead, please.
Thank you very much. Like I said, the act that this bill is attempting to amend has been in existence since 1933. And we all know that we are in a democratic process now. And most of the things that are there might not be deemed democratic in this day and age. Honorable Speaker, I can go on and on and on, but since we are only on the merits, and most of us are not legally minded, I would recommend this bill, even though it's going to the ABC, but I will recommend the ABC to consider the Human Rights Committee, who would in turn consult certain experts to thoroughly look at this bill. Honorable Speaker, we've seen what happened recently based on Section 154 of the Criminal Offences Act, which we are trying to amend now. Section 154 on false publication and broadcasting. If we do not look at this thoroughly, because what is deemed as false publication might infringe one's democratic rights. Honorable Speaker, I also go to, like I said, I can go on and on and on. I can, for example, I'll give you section 51, the delivery of prohibited publication to police station or administrative officer. Honorable Speaker, a person, it says a person to whom any publication, the importation of which has been prohibited under section 49 or any extract therefrom is sent without his or her knowledge or privity. Madam Honorable Speaker, we need to look at these provisions because in 1933, when these laws were made, rights were very restrictive. And this day and age, we live in a democratic world and we are striving to be more democratic. People's rights should not be restricted. And I think we should not rush and look at this. Honorable Speaker, again, I will go to the laws regarding attempts to procure abortion. Honorable Speaker, abortion at times might be legal, depending on the status of the person that seeks for the abortion. So we need to look at it. There might be medical terms. So abortion cannot be just stricken and termed illegal in all cases. So, Honorable Speaker, the merits and the reasons for changing this, I think it is welcoming, but we need time to look into it and to look at the state of affairs that we currently live in, not only in the Gambia, but international best practice. Look at what is more democratic. Honorable Speaker, we are seeing how rights are being infringed based on the laws that govern this bill that we are trying to amend. And Honorable Speaker, we must look into it thoroughly, consult the stakeholders, consult the citizens that are affected. For example, you send a parcel to the post office. Madam Speaker, it states here that the post office has a right to examine. Yes, they have a right to examine, but they also, the person or the owner or the sender has a right to be consulted and to be there when the parcel is examined. Otherwise, anything can happen. That is infringing your rights, Honorable Speaker. So we need to tread with caution when we look into this, because it is not only accusing somebody of crime, it might be infringing in their human rights. So I would recommend that this bill, I would call for the ABC to consider the Human Rights Committee to thoroughly look into this bill to ensure that the citizens are given their human rights and they are protected to the highest form. Thank you, Honorable Speaker. I will leave the rest of my debate until that stage because I am a member of the Human Rights Committee. Thank you.
Thank you, Honorable Member. Banjul North, the floor is yours.
Thank you very much, Honorable Speaker. Honorable Speaker, it appears that the wheel is being reinvented. What we have before us, Criminal Offences Bill, according to the objects and reasons presented by the Honorable Attorney General, Minister of Justice, is that this is the first attempt at undertaking a comprehensive review of the Criminal Code of the Gambia since its enactment in 1933. And the bill seeks to align the criminal justice legislation with current trends by removing all provisions inimical to freedom of speech, such as criminal defamation and sedition. So it appears that the Criminal Code is what is being amended. we have been given the whole law, the whole act, of course, with these additions aimed at improving on it, for it to be in line with current trends. And what I was expecting is that for the executive to come up with amendments, rather than the National Assembly considering the whole act with this amendment, because these are amendments, so to speak. So that's what I was expecting, that they would be coming before us with amendments of the sections that they want to see removed, that are inimical to democracy, to freedom of speech, to whatever that is retrogressive, whatever that is retrogressive, that is and then inject progressive elements, rather than giving us this whole act to consider. Yes, I'm not sure whether the necessary consultation had been done before coming here by engaging the practitioners of law, members of society, civil society interests, on the elements that the executive wants to see injected into the law or to see removed from the law. In that regard, I would suggest that the executive goes back and then identify the areas, the provisions that are being amended. And I would want to hear from the Honorable Attorney General, Minister of Justice, that this is my perception, that these are amendments. And I would, as amendments, as the practice has been, it's just the amendments that would be treated as the previous business that was before us, immediately before this. It's an amendment of a parent law. So this is what I was expecting, because this is very comprehensive. We are the lawmakers, though, but we don't have the expertise in terms of, well, some of us. Not being a lawyer does not mean that you do not know the law. But some of us is really going to be very challenging, and that I would really prefer, I don't know whether I move the motion now, but I allow, like I said, let's allow others to come up. But that is my take on this, that this is a matter that should have been brought in the form of amendments, making it easier for us to do the necessary consultation, necessary review, in order to make substantive contributions to it. So, on that note, Honorable Speaker, I would want the Honorable Attorney General to consider the proposal that I am putting forth, that it is better that they go back to the drawing board, bring us amendments for our consideration. Thank you very much.
Thank you, Honorable Member. May I now call on Honorable Member for Upper Fuladu.
Thank you, Mr. Speaker. Similar comments. I just want to say that the ABC needs to, once the motion is passed, the ABC needs to do justice by engaging all the relevant committees that they see fit to actually take part in this, because some of the offenses or some of the issues here are cross-cutting, and I think it's very important that not the Human Rights Committee be engaged, but other committees to be considered. There are issues here that, although I can see that the AG's office has done quite an extensive amendment to the old law. However, still, there are some disturbing provisions in this bill that I believe still does not conform to international best practices. And I think we as lawmakers should also be very careful in during the consideration stage, clause by clause, to look at these provisions, because they could be prone to misinterpretation. Given the distance since 1933 to now, some of the languages, like for example, Section 152, fouling air. I don't understand. Fouling air, does that mean if somebody fouls or do something, is that part of? So you should be a little bit more specific, into what does that mean, because this provision here is still ambiguous to me. Section 154 is, I think, one of the most important of this bill. I think we've just seen, like Honorable Member for Banjul South mentioned just recently, still, in as much as we're trying to depart from the past, we're still having difficult, with some of the security actors still abusing some of these provisions to infringe in the fundamental and constitutional rights of citizens. So on that note, I will leave it here. I think other members want to contribute at this point, but this is one document that we do not need to hurry and table and pass without doing due diligence. Thank you very much.
Thank you very much, Honorable Member. May I now call on Honorable Member for Woolly East.
Okay. Thank you, Honorable Speaker. Honorable Speaker, I have tried to go through this bill, and I believe that laws that have been made since 1933 require looking into, reviewing. And I think it is about time that Gambia also looks into these archaic laws to bring them in conformity with modern times. Honorable Speaker, I believe the objects and reasons can be broadened to include, for example, examples of challenges that have been encountered in the implementation of the old laws. What have been challenges that were encountered during that time? Maybe just an example, one or two, would have enriched the objects and reasons. Also, Section 62, which deals with definitions. I think this assembly should look closely to meanings like definition that is given to unlawful assembly. Because unlawful assembly is saying where 3 or more persons assembled with intent to commit an offense or being assembled, etc., etc. The section needs to be looked at closely to ensure that it does not infringe the human rights of Gambian citizens. Honorable Speaker, I'm also concerned about how the law arrives at or determines what is maximum and minimum punishment. Sometimes punishment can be very exorbitant, or fines can be very exorbitant, and maybe the person has just committed a small or little infringement, but then the punishment can be more. So if the Attorney General will help us, how do they arrive at maximum and minimum fines and punishments? Because if you go to Section 35, it will give you fines, cost, and compensation. All those things are there. Also, Honorable Speaker, if you go to Section 5, it is saying ignorance of the law. It's an old thing. Ignorance of the law is no excuse. It looks like, even though it's not written in that way, But I think that is something that we need to look at. And not only looking at it, but also coming up with a provision to ensure that any law that is made is adequately sensitized, the people are adequately sensitized, so that they'll be able to know that this law is in existence. And they'll also be able to know the repercussion of infringing that law. Because we continue to make laws and the citizens are not aware of the laws that we are making here. And they continue to operate as usual, and only to be told that being ignorant of it is not your defense. Like it is said here, ignorance of the law does not afford any excuse for any act or omission which would otherwise constitute an offense, unless knowledge of the law by the offender is expressly declared to be an element of the offense. So I think this may be progressive, but I believe that we need to look at it more closely to ensure that our people are adequately sensitized before any law can be implemented in the Gambia. So on that note, I thank you very much for the time.
Thank you very much. Honorable Member for Janjambure, the floor is yours.
Thank you, Honorable Speaker. I just want to join my colleagues to say this bill, when you go through it, it has a lot of important subjects that deal with our people. And I would go by with what Banjul North and Upper Fatou says, that when it goes to the committee should look at it properly. It deals with very sensitive issues from unlawful assembly to treason, you name them. The committee that it will be assigned to should ensure that every stakeholder should be invited when they discuss this. And I'm advising that before it comes over, or maybe when they are meeting, a lot of members may want to be part of the discussions at that stage. Like Banjul North says, it is important, and if you are not a lawyer, probably you may not understand it in detail. And therefore, it is at that stage that the lawyers would come, or the stakeholders would come and explain in detail what they mean by, for example, an unlawful assembly. So on that note, Mr. Speaker, I also recommend that when we send it to the right committee, they should do a thorough consultation on the matter. Thank you.
Thank you, Honorable Member. May I now call on Honorable Member for Jara East. Honorable Member for Jara East.
Thank you, Honorable Speaker, for giving me the floor. I rise to contribute my quota with regards to criminal offences bill that is before us. And I must first of all thank the mover for having the foresight to bring this important amendment before us. Honorable Speaker, you will agree with me that the essence of amendment is basically to do some legal tinkering. Madam Speaker, and that's what we are, Honorable Speaker, and that's what we are confronted with. You will agree with me that, Honorable Speaker, we are talking about a law that has been in existence for 8 decades plus. That is 87 years, from 1933 to date. And when laws are made, they undergo passage of time. They undergo passage of time, and therefore the need for us to do an element of legal tinkering cannot be overemphasized. Honorable Speaker, 1933 to date, some of the provisions have outlived their usefulness, and as a result, the need for legal tinkering is just in line. Honorable Speaker, I'll join my colleagues for these important criminal offenses to be committed to the Committee of ABC and to be further committed to the Committee of Human Rights and Constitutional Matters so that it can be thoroughly scrutinized. This bill can be subjected to a thorough overhaul. And I believe if that is done, it will provide us with an idea of how to deal with some of the provisions. Without much ado, I will thank the mover for a job well done. Thank you very much.
Thank you very much, Honorable Member. May I now call on Honorable Member for Brikama North.
Thank you very much, Mr. Speaker. The bill before us is the Criminal Offences Bill 2019. And in the objects and reasons, we have been told that the Criminal Code of the Gambia had been subjected to thorough review since its enactment in 1933 for the first time. In that regard, as the Honorable Member for Banjul North rightly indicated, I consider this to be a product of the review of the Criminal Code. And then when the revision was done, certain provisions that are inimical to freedom of speech were removed. When that is done, I consider that to be amendments that were made onto the Criminal Code of the Gambia. Then I think it will be important if the Attorney General can put us right, whether we have a first criminal offenses bill that is to be tabled, or whether we are dealing with the amendments that were made on the Criminal Code of the Gambia. I think the objects and reasons should marry with the title of the bill. Now, if it is intended for providing necessary amendments to the Criminal Code of the Gambia, there are salient issues that are inimical in our lives, which I think at this juncture one may not find time to dwell into that, but allow a relevant committee to dig into that in consultations with the experts in the area. However, I would like once more for the Attorney General to shed light whether it is the Criminal Code of the Gambia that is amended, or we are having what he called the Criminal Offences Bill.
Thank you, Honorable Member. May I now call on Honorable Member for Tumana. Honorable Member for Tumana.
Tak.
You didn't? Well,
no.
According Honorable Member for Basse.
Mr. Speaker, thank you very much. I use the opportunity to join colleagues who have spoken before me to thank the Minister and his team of experts. Questions were raised before I stand. I will not repeat those questions, but they are my concern if I get answers to those questions. In addition, Honorable Speaker, I want to refer the August Assembly to the Constitution Section 7, which reads the laws of the Gambia. And if you turn the page, we go to E. It's a customary law so far as concerns members of the communities to which it applies. And F reads the Sharia as regards matters of marriage, divorce, and inheritance, among others, of the communities to which it applies. Honorable Speaker, in this document, if you go further to Part 8, it's referring to offenses relating to marriage and the domestic obligations. Terms are used here which are not interpreted into the interpretation parts, like if you say lawful marriage. What do you mean by lawful marriage? Considering the Gambia as a religious state between Christian and Muslims. And the Muslims' marriage, according to the Constitution, it should be guided by the Sharia, and the Sharia is a law of the Gambia. So therefore, whoever committee this bill might be referred to, I would like to inform them, let them consult that section or this segment of the society so that they can help us to align this principal work to the religious beliefs of the country and also the customary beliefs of this country, as far as they stand as part of, as they stand as laws of the Gambia. So this is my observation. I thank you and I beg to resume my seat.
Thank you, Honorable Member. May I now call on Honorable Member for Serakunda? And he is last on my list if any other Honorable Member wants to take it.
Thank you very much, Honorable Speaker. The object of law is clear. It is to prevent, to prohibit, to promote, and to ensure that there is normative practices that will foster justice to self, to others, and the environment. The whole object is to ensure that humanity lives as we should. Honorable Speaker, we are supposed to discuss the merits of the bill. We are told that the bill is the first attempt to undertake a comprehensive review of the criminal code of the Gambia, which was inherited from the colonial administration, and the provisions are largely situated in what constituted crime in that jurisdiction. Honorable Speaker, looking at the content, one will see some changes, but huge importation from what existed in the past. And this is showing that the administrators are being very careful in not overhauling everything and inventing what is new. But notwithstanding, still wishing to leave a legacy of having a new start. Honorable Speaker, the bill has 38 parts, moving into the terrain of determining the territorial application of the Act and moving into criminal responsibility or liability. Should you say that when somebody is ignorant of the law, then the law does not exist and the person should not be penalized for crime? What about the immature age? Should it be 12?
Should it go further? So these are issues where we need the public mind. It is wrong to say that laws are for lawyers. And this parliament must change its mentality. Parliament is the lawmaker. And when the lawyers interpret the law, they try to know the mind of parliament. So if parliament does not have a mind, then there is no interpretation of the law. So it is important that we understand that parliament is the lawmaker. And parliament must know the mind of the public, refine it so that it feeds into the law, so as to ensure that whatever is injurious to the person, to public health, public morality, to the environment, is actually catered for in the law. So that by knowing what the law says, it will guide our normative practices in society, and all of us will be equal under the law. But a law that is just. So the object of the law is to create that environment, that foundation that will protect all of us. And that's what we are here charged to do. Honorable Speaker, I've seen part 7, which deals with punishment. And I browsed through it, and I've seen what it lists down. But what is a bit worrisome is what is indicated as the last item. Honorable Speaker, the punishment, if we look at 32, which details the kinds of punishment, clause 32, and you look at H, well, from A down, you believe that death penalty is no longer a part of the punishment. But then if you look at H, any other punishment prescribed by this act or any other enactment. So that is the sky. Who will be making the law? And what sort of punishment? Are we conclusive regarding what should be the severest punishment in our country? And this is where my questions will come to the Honorable Minister. Honorable Speaker, the issue of treason is there. The issue of sedition is there. Honorable Speaker, offenses against public tranquility is there. So these are all issues that we need to look at critically, not only from our jurisdiction, but jurisdiction of other courts which we are subjected. There are international criminal courts, African courts, other sub-regional courts emerging, which may have criminal jurisdiction. So essentially the issue of rights come, how they are conceived. So we are not only talking about Gambia, but we are talking about Gambia within a community of nations. So if we want to review what is archaic, we must take into consideration all factors so that what we have will not fall short of what the standards are globally. Honorable Speaker, I'll just show you one dimension, which has been very offensive, 143, 144, which essentially has been, I will call, victimization of the poor. because the objective of the law is to protect people from injuries, from annoyances, from prejudices that affect the life of the human being. You don't want the person to be injured in body or in property. You don't want others to be injured. So, in essence, Honorable Speaker, this idle and disorderly persons, will I ever be charged under these rogues and vagabonds? You see, these countries at a given stage of their development excluded the poor from development to a point that people were homeless and they had to move about and they stay in street corners. And those who had wealth did not want their wealth threatened. So anytime they come close to their properties, they had the right to call the police and they'll be arrested and dumped away. So what I see here is no change. Should this be our conception of crime and lawmaking? So in short, Honorable Speaker, Gambia is in transition. This is a necessary act to review our criminal code and reinvent it, situate it to the current demands of not only our country but the world at large. But, Honorable Speaker, the work is not yet done. A constitution is yet to be promulgated, which would have great impact on what our criminal code would be. TRRC is yet to complete its work. National Human Rights Commission has been established. So it means that already there are state institutions designed to address the issue of human rights and justice. And therefore, consultation at the level of institutions we have created would have been most significant before we do the review, so that we take on board every development that has taken place in the modernization of our criminal code. Honorable Speaker, whilst the exercise is absolutely necessary, commendable, the mere fact that the intention is there to review what essentially had been colonial inputs into our criminal justice system, but it is essential for us to incorporate modernity that is not only imprisonment. What is alternative to imprisonment? What is being done in other jurisdictions regarding punishment? All that should have been re-examined, clause by clause. What type of punishment that will not just be vindictive, but is rehabilitative, should have been the conception in terms of punishment and the establishment of the criminal code. So, Honorable Speaker, I'm inspired that an attempt is made to review, and we have the competence to have our committees invite subject matter specialists to look at every item and have an input. But I would have been more inspired if this was withdrawn by the Honorable Attorney General and then allow the constitutional process to reach its final phase. All these instruments that we have, institutions we have created to complete their work, and then look at what they have got and sit down like with the Human Rights Commission, have stakeholders discussion on the review of the criminal code before ultimately the provisions come to Parliament for review and enactment. Honorable Speaker, that is my position.
Thank you, Honorable Member for Serakunda. May I now call on Honorable Member for Bundunga Kunda? And that's the last on my list. Any other Honorable Member who wants to partake? Okay. Honorable Member for Bundunga Kunda, please.
Thank you very much, Honorable Speaker, for giving me the floor. I would like to equally thank the mover, by extension his predecessor, to come up with this bill at this crucial moment of the new Gambia we are trying to build, Honorable Speaker. Honorable Speaker, the law on criminal procedure has a purpose of establishing the rules that shall be respected, strictly implemented in order to undermine the existence of the criminal offense. Any criminal offense may give rise to two separate legal actions. Honorable Speaker, looking at the objectives and the reasons of this bill, it rings a bell in my mind of what is happening, the realities on the ground, especially concerning about the criminal procedures that is going on in the Gambia here. Honorable Speaker, if I may read at the objectives and the reasons. It says this bill is the first attempt at undertaking a comprehensive review of a criminal procedure code of the Gambia since the enactment in 1933.
Point of observation.
Observation, okay.
You need permission from the honorable member on the. You give him permission? Okay, thank you.
Honorable Speaker, the member is talking about procedure, criminal procedure code. What we are dealing with is criminal offenses bill. Thank you.
Honorable member, you can go ahead, please. I don't think there is any. No. Different, yeah.
So we are dealing with the criminal offense.
Thank you, Honorable Member, for that ratification. Honorable Speaker, as I said, looking at what is happening, need to be or has very little to be desired with. What is happening, I think it is high time we look at these criminal offenses, because I think on my observation, the police or the state institution that are entrusted with this sometimes, because of the ignorance of our populates, sometimes they are being taken a ride of what usually should happen to them. Honorable Speaker, Honorable Speaker, I think I will. I mix up everything. Yeah, thank you, Honorable Speaker.
Thank you, Honorable Member. The last on my list, Honorable Member for Woodley West, please.
Thank you, Honorable Speaker. Honorable Speaker, we have a bill which is not an ordinary bill at all. It's very far from being an ordinary legislation. But what is of great surprise is that even though we became sovereign in 1970, we refused to decolonize our laws. And this is one of the fundamental laws that were used by the colonial administration to make us as they wanted us to be. And now, since 1933, at the height of colonization, up to 1970, and from 1970 to date, no attempt has been made to bring a bill of this nature to this assembly. And I think I would agree with the member for Serekunda when he suggested that the Attorney General consider withdrawing this for reasons that he has elucidated. Because we have a model law in the making, which is not established yet, and from which such laws are going to take their inspiration. I think it is important that we deal with that first to be able to deal with this type of legislation that we have. If I say, for example, unlawful assemblies, which is a controversial thing, because the Constitution grants me the right to assemble. And that's the model law. And yet, there is another requirement that I have to have permission to assemble. Are you not negating that model law? You are. By the simple fact that denying me the fundamental right that the law grants me to assemble peacefully, and even the word peaceful is there, I still need another permission, which means that, in fact, the permission is even greater than what is supposed to be the mother or the father of the law. So it is important that we know what the model law contains in relation to this particular thing before we, you see, what we are asked to do here is monumental, legally monumental. First, we are asked to define what is a crime, what act constitutes a crime. That's what we are asked to do. Members, let us be very serious about this matter. We are asked to define what constitutes an offense, an act which constitutes an offense in a republic. And then we are also asked to define or to mete out penalties for such acts. This is not easy. You are laughing, but we are not thinking seriously about what we are asked to do. For me, when I look at this document, I spent the whole night yesterday looking at this. That's why I feel somewhat sleepy right now. But it is so important that we cannot just rush with this. We have to look at every single clause of this legislation, these bills. Every single clause must be critically examined. And then we draw conclusions, because we are supposed to say what is a crime in terms of action and what is going to be a penalty for that. And I see some funny headings there. And this one is like an import from the colonial law that we are trying to decolonize. If I take a look at clause 217. It's a habitual dealing in slaves. And the clause is saying a person who habitually imports, exports, removes, buys, sells, traffics, or deals in slaves commits a felony. Don't you think this is not an import? There is no change. This is the colonial law. Absolutely, because in our law, slave, the word slave is an offense. According to 1970 Constitution, anybody who tells you, you can take him or her to court for calling you a slave. Now we are talking about this. This must be lifted from, it's important that we know. You should have provided us, Honorable Speaker, we should have been provided with the law that we are amending, so that we have an idea we are dealing with. Because we are trying to throw overboard a particular law to put in place something else, but it seems that they are importing from that law into this new one. So we have no idea, because for me, when I read this, I say, what is this like during the time of slave trade? This provision is like referring to the abolition of slave trade. So we have to have an idea as to, I think it is not too late. It's not too late that we are giving copies of this so that we know exactly what we are doing. Honorable Speaker. And then, clause 122, unnatural offenses. What is an unnatural offense? See, these are no easy. I don't want to go to that level, but I know we are in a totally different world now. Every country is multi-everything. What is unnatural to you may not be unnatural to somebody else. What is unnatural to you may not necessarily be harmful to anybody. So, we are making law, we are not making law to change it tomorrow. We are making law to last the test of time. So they are very critical issues that they are raising in this bill. And for me, I need to read this 10 times. Yesterday, I was spending almost 30 minutes on every clause. And sometimes, I must say, I'm impressed by the linguistics of these draft persons. The linguistics of this document, I'm impressed. Sometimes I laugh because the way they coin things impresses me. But sometimes they have difficulty. They resort to what I call meta-language. But because if you are defining sedition, and you are repeating sedition to define sedition, that's what we call meta-language. You are not telling me anything. If you say seditious and you are saying, what is seditious? What is seditious? What is seditious? You see, language, we use language to define itself, it becomes a meta-language. That's above language. So you have clauses, we'll deal with them when we come to committee stage, if you don't withdraw it. And I hope you are going to withdraw it. To give us time to look at things more critically and to make it possible for the Constitution to come in place so that we know what exactly it contains before we deal with this. Because I'm sure we are not viewing this from the point of view of the 1997 Constitution, because it's also in the process of being replaced. I don't know when it's going to be replaced, but it's very important. So, Honorable Speaker, there's a lot that I want to say, but I think I'm going to reserve my energy for this critical. We should not even be debating. We should look at the committee stage. Whichever committee this document is going to be deferred to, will invite people, whoever is interested, go there and we critically look at these things, clause by clause, so that we are not insulted by posterity. Thank you.
Thank you, Honorable Member.
The last one.
Yes, the last. Then I will invite the Attorney General. Attention, The honorable member for Woodley West is last on my list. If no other honorable member wants to take part in the debate, I will now invite the Honorable Attorney General and Minister of Justice to respond to issues raised and wind up the debate. Honorable Justice Minister, please.
Thank you very much, Honorable Speaker. I will try to keep it short because I agree with members that probably this might not be the appropriate forum to deal with the specific concerns that are raised. Probably we do that at technical level. And by that statement, I'm giving a hint that we probably are not withdrawing the bill. So I'll look at the ones that are general in nature. I try to address them. But let me give a general answer first to those who probably think maybe the best way out would be to withdraw. And some of the reasons that have been advanced has to do with the constitution that is in place and some of the transitional processes that are as well ongoing, for example, the TRRC. Actually, one can say we are caught up in between because the thinking as at now, the ministry is already thinking ahead of time. What do we do with the recommendations of the TRRC in the event they round up and they recommend certain things such as prosecution? Do we even have some of the offenses that they might recommend people to be prosecuted on in our criminal codes? These are questions that we are looking at. Some of those offenses don't currently exist in our criminal law. So waiting for that process to conclude would not do much because criminal law is such that it does not normally have a retrospective effect. So we already know what we are dealing with in these institutions. We are already aware of the challenges in terms of the penal code that exist and that we have discovered by virtue of those transitional processes. And I can assure honorable members that those concerns are already taken on board in this draft bill. With respect to the Constitution, usually criminal offenses are usually very standard, except for few. And we have an existing one, which is very much archaic. And there is a need to modernize it. And currently, the timetable of the draft Constitution, vis-a-vis other transitional processes and other cycles like elections and others, is very tight if some of you are paying attention to it. And it was very challenging if these processes are all interlinked. For one process to be put on hold for another process makes the whole thing a little bit more difficult for us to manage. And all of them are priorities as well with respect to our transitional justice system. So all these things are priorities, they are interlinked. The ideal situation is they should all go simultaneously, they cannot go simultaneously. But keeping one to wait for the other to conclude also will even make life much more difficult for us. So we propose that we proceed with this bill. I agree entirely with those, especially Honorable for Woodley West, that just was the last speaker, that if I'll borrow his expressions, it's a bill of monumental importance. No doubt about that. Because it is true, you are invited here now to define what constitutes an offense in the Gambia and what will be the corresponding punishment for every single offense that has been agreed to be an offense. So, in essence, this is going to be our penal code. You are the representatives of the people. You are the ones that are vested with the legislative power. So this is an important assignment. Always you do important assignment, but among them, this is especially important. But that's for you. That's your job. We've done our side we've done our consultation at our side. I can assure you this bill, for those who might not know, has been subjected to a national validation where civil society was invited and they have participated. So at our level, the concerns of civil society is already on board. But consultation at our level is different from consultation at your level. So you can do your consultations with your electorates or other stakeholders that probably you would wish to consult. And we will still be around even at the technical level. Because at the end of the day, this law is very, very important. Diluting it too much too will have boomerang effects on society. Because this is the principal law that regulates our conduct in society. This is the law that prohibits us from doing certain things and permits us to do certain things. So if we don't have it and have it in a standard way, it will bring us a lot of challenges. Now I'll attempt to go one by one from the various speakers for those who raise issues that would require our response. Banjul South, the concern is more or less, in my view, internal. That is, if it gets to committee level, they need to involve the Human Rights Committee and others. I believe that is noted. Banjul not needed clarification as to, because according to the objects and reasons, the Honorable Member is saying they are of the expectation that amendments will be coming, but it looks like we're getting a comprehensive bill. Our response to that is, our intention is to amend. But like other speakers have said, and indeed we amended, but the amendment is so comprehensive, like we stated in the objective, that it is an overhaul. Because we cannot be doing it in piecemeal. A legislation that is more than 80 years old, you cannot be changing one. In fact, that has been the culture. It doesn't mean in the past 80 years it has not ever been changed. Various sections of the criminal code has been changing. But we come to realize that those piecemeal amendments are not just going to solve our problem. So they are so comprehensive that is why in the end we are repealing the old one completely and replace it with this one. So yes, we intended an amendment, but it's so comprehensive that it constitutes a new bill altogether. So we are going to repeal the old one if this one goes through. Some of the reasons for that also would be, Honorable Fowuli mentioned it, the drafting style of legislation 80 years ago and now have changed drastically. So some of these offenses, the way they are to be drafted will have to change. So they may even still be relevant, but the way they are drafted, the language and style has to change. So as a result, you will see some offenses will stay, but their definition and everything will have to change to commensurate to the standard now. So that's one of the justifications why we believe we need an overhaul. Honorable Member of Fuladu, Upper Fuladu, I think it's more of an emphasis that issues are cross-cutting and they are so important and time needs to be taken. So I can only agree with those who are calling for you taking your time and go into details. Of course, nothing less is expected. I remember the Honorable Member for Basse reminded me last time that in fact I was the one who was saying this during your induction. So of course, take all your time that you need and scrutinize the bills. That's actually your job, and I couldn't expect anything less. Some other issues are specific. We can leave them to technical level. We can interact at that level where some specific concerns are raised about definitions of certain concepts. I think this is Honorable Member for maximum minimum punishment was raised by, I think, still Upper Fuladu or somebody else, if I'm not mistaken. Oh, it was Willie. Then I missed that. Yes. Now, the consultants looks at various indicators. They look at what obtains in common law jurisdictions around us, because we cannot legislate in isolation. We have to meet up to standard. But also they look at the economic situations in the country and various factors. So they are guided by expert knowledge and considerations. Ignorance of the law has been raised by Wulli East, and I think Serakunda or Wulli, somebody also made passing mention of it. Of course, yes, that is the situation. The emphasis here should be how do we make people become aware of legislation. But not knowing the law, of course, is an old adage, and it's still relevant. Unless knowledge of the law is a requirement, is an element of the offense. All right? Like sometimes an offense that is defined to require that when you knowingly do something or where knowledge is required. But it has to be knowledge of the law. That is the only time you can say, I don't know. Because sometimes knowledge is required, but not knowledge of the law. Maybe knowledge of a particular fact or something. But unless it is expressly stated that you require knowledge of the law, the lack of it would not be an excuse. Of course, if you don't do that, everybody will come and say, I never knew this law existed, and everybody will go home scot-free. So once the law is passed following the normal due process, and it is gazetted, it is deemed that every member of society is aware of it. Because you are the representatives of the people. If it comes here, this is the Bantaba of the community, of the whole country. You have your electorates. But also, if it is published in the Gazette and all those due processes are followed, then people are deemed to be aware. Although I agree entirely with you, further steps need to be taken after promulgation or enactment to enlighten the community. But that can be treated separately from the legislative process itself. Janjambure also emphasized the importance of consultation. I agree. Jara agrees that the review is timely because most provisions are out. They have outlived their usefulness. I agree. Rikama not repeats the same concern as to whether you are faced with an amendment bill or a new bill altogether. It's a new bill straight away, but it's a bill that is amending an old one. It's not a bill that is coming fresh. So it's both, because some bills are dealing with subject matter that never existed in our laws before, which are completely fresh bills. This is new bill with the effect that it is an amendment bill, but it has the effect of replacing the old one completely. So the answer is yes and no, it's both. It's an amendment bill, but the amendment is so extensive that technically it repeals the old one. But it is not a new subject matter. So it's a new bill, it's an amendment bill on an old subject matter, but it repeals the old law in that area. Honorable member Basse did not touch on the bill itself. You raised issues regarding Section 7 of the Constitution, which deals laws of the Gambia, and paragraph E dealing with Sharia applicable to members of the community which are Muslims. Of course, I think your emphasis is to the effect that at committee stages, I think the relevant authorities in that regard need to be consulted. I can't agree more. That's okay. Anybody calling for extensive consultation, taking of your time to look at it seriously, we have nothing adverse to that. Honorable member for Serakunda, he has read our intention very rightly, what the executive is trying to do. Yes, we intend to leave the legacy, but it's a mixed bag. Like I said, some things that are criminal offenses in the past still remains criminal offenses. They would not change. So for that reason, you will find them even in this new one. But probably their definition might change slightly, or probably the punishment might change slightly. But they will remain. But there will be some that probably were not offenses before. You will find them there as offenses. Because one thing that informs this review also is We've got experienced several situations where clear offenses have been committed. You cannot handle them either because the courts don't have jurisdiction or they are not defined in our laws as an offense. And a criminal offense is such that you cannot charge somebody of an offense unless that is an offense defined in a written law to be an offense. Right? So unless we write all our offenses in a book, you cannot charge somebody for an offense, no matter how outrageous the act is. If it is not considered to be an offense in our penal code, you cannot prosecute somebody for it. So some situations, based on those experiences of our law enforcement officers, including our office, we've come up with some situations where the jurisdictions of the courts have been expanded. Territorially, it remains the Gambia, but we looked at offenses that can be committed across the border. We also look at the individual, the personal jurisdiction, the courts to assume jurisdiction over certain individuals whom previously the courts would not have jurisdiction over. This is all with the view, ultimately, this law is, let's never lose sight of that, is to protect all of us. It is to protect all of us. Although in doing so, we should be mindful of the law itself not being used as some of you would argue, as a medium or as an instrument to violate rights. But the intention is never to violate rights. The intention is to preserve law and order in society. Honorable Member for Serekunda still mentioned of Part 7, the punishments, and he has raised concerns about the issue of any other punishment prescribed by this Act or an Act of National Assembly. I'm not too sure what is the concern about, but a list is given. At the end of the list, we don't want to close it completely. So we say if any other legislation prescribe any form of punishment too, it will be recognized. So long as it is a form of punishment prescribed by law. Because we are not too sure whether the list that we have created will be exhaustive. So you always leave that room. But of course, this will be punishment that is approved by Parliament. So that is what the any order is going to be. But like I said, most of these things will be further looked at committee level, where we interact and look at these things. He's raised concerns on treason, sedition. Honorable Member raised an important point of, well, you're concerned with idle and disorderly, Section 143, and rogue and vagabond, Section 144. But one area that I believe together we can look at is alternative forms of punishments that the Honorable Member raised. And I agree, technically we can both look at that. Myself, I must admit, it's not an excuse, but we will look at this with you at committee level, and so that we are in line with best practices. We not only punish people for the sake of punishment, but ultimately we want to achieve, when they serve their terms, for example, if it is an imprisonment, they turn out to be better persons instead of worse than before they went to serve their term. So what are the alternatives to imprisonment or vindictive forms of punishments? We agree we will look into this with Honorable. But Honorable for Serekunda is the one who emphasized more of us considering withdrawing. We believe this bill is still relevant. We believe the passing or non-passing of the Constitution, the draft Constitution, will not have far-reaching consequences on this bill. It may, but it may be very minimal, and that can be taken care of. But we still need a complete overhaul of our criminal law. So we still maintain that the bill be proceeded on to be considered by the House. And the member for Bundung-Kakunda, okay.
Sorry, I thought I was...
Yeah, I know your name is here, but I now realize, okay, your position was corrected. And Honorable for Woolly West equally is concerned as to what will be the implications of some of the provisions in the criminal code vis-a-vis if the Constitution is passed. In fact, to allay your fears about the Constitution, it is the supreme law. If we define anything as an offense in this criminal code, if the Constitution says tomorrow it is not an offense, then this provision in the criminal code becomes null and void. So I don't believe then that should be an issue to stop us from proceeding with the criminal code. Yeah, so whatever the Constitution says tomorrow will be final. So if we criminalize something in our criminal code today in this bill, tomorrow the Constitution considered it as non-criminal, then the provision in the criminal code does not stand anymore. If you charge somebody on it, it goes to court, it will fail. Because the person can rely on the Constitution. So we'll take note of that. But if such situations happen, we will probably do a simple cleaning of that. But we believe what we stand to gain by considering this bill outweighs those concerns. That's our policy position at the moment. Still honorable for Woolly West, the issue of slave dealings and unnatural offenses. The issue of slave dealings, let me reserve our comments on specific concerns of specific sections. Then we will deal with them when we meet at technical level. Some of these things might need some little bit of technical explanation, but of course we can agree or disagree whether they should stay. It's entirely in your prerogative. Our role as technicians will be trying to explain them to you so that they are clear. The decision is yours, but the position is they are relevant sections that needs to be kept. Probably we'll try to do the justification when we meet at the technical level to see whether we will convince your concerns, convince you on your concerns or otherwise. So I do not intend to take much longer than necessary, but Honorable Speaker, we have a collection of a lot of novelties that we are introducing into this bill, which I believe are things that can convince this Honorable Assembly that we stand to gain a lot by changing this law as it is. Of course, with your concerns taken on board and whatever suggestions you want to bring in. But there are a lot of new things that we are bringing in that will show the distinction between the old criminal code and the new one that we are proposing. Just to give a hint of some of these things, I wouldn't go thoroughly to all of it. We have tried to outline some of them. For example, I made mention of the extent of jurisdiction of the courts, which you will find under Section 4. But I agree with Honorable for Woolly West. We will provide the old criminal code, and then we will have a comparative basis of, where are we departing from, and where are we going to be by virtue of this amendment. Then probably members will be able to appreciate the value of the amendment better, because you will see where we were and where we intend to take you to. But quite a lot of improvement have been made. They are listed. Probably we will try to make copies of those ones as well and make them available to members with the objective of just enriching your deliberations at the committee level. But respectfully, Honorable Speaker, we still beg to maintain the bill on the floor of the House, and we urge members to continue to consider it based on the facts that I've said earlier. Thank you very much.
What is your clarification? Clarity, Honorable Member for Serakunda.
Yeah, Honorable Speaker, would the Honorable Attorney General look at Section 24, subsection 5? So I just want him, because it was not my intention to say that we wait for the TRRC so as to proffer criminal charges against someone which did not constitute a crime, because of this particular provision that if something did not constitute a crime before, then you cannot have retroactive effect in charging that person. The whole intention, which I need clarification on, is that since we are talking about a legacy, that's my position. What the policy of government, 24 of the Constitution, subsection 5, yes. Yes. I'm just concurring that, that no person can be.
Of course.
Yes.
Yes.
For something that was not a crime. So
exactly.
I'm not really focusing on the criminal element of that.
Thank you.
But more rather the consultation of the new thing, the broader horizon, what type of criminal justice system are we going to have after that? But as you have said, alternative.
We've taken note of the developments in those processes
yes,
already.
Thank you.
Yes, thank you. Thank you very much, sir.
Thank you. Honorable Banjo, again. Honorable Member for Banjul South, on what do you want to, clarity on what?
Clarification on some of the definition. Or
Please, I think we'll now go ahead.
is Honorable Speaker.
Honorable member, please. Honorable members, it has been moved and seconded that the bill entitled to the Criminal Offence Bill 2020 be read a second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. If not carried,
Criminal Offences Bill 2020 is hereby read a second time.
Honorable members, in accordance with the clause 68(1) in bracket of the standing order, the bill is hereby referred to the Assembly Business Committee for committal to either the committee or committees of the whole House. Thank you. Clerk, please proceed.
Second reading of the Criminal Procedure Bill 2020 by the Honorable Attorney General and Minister for Justice.
Thank you. Honorable members will recall that the first reading of the Criminal Procedure Bill 2020 was done on Monday, 22nd June 2020, and today is the appointed for the second reading in accordance with Standing Order 66-2. Therefore, in pursuant to Clause 67 of the Standing Order, I now invite the Attorney General and Minister of Justice to move a motion for the second reading of the bill entitled to Criminal Procedure Bill 2020. Honorable Minister.
Thank you, Honorable Speaker. Honorable Speaker, I wish to move that the bill entitled Criminal Procedure Bill 2020 be read a second time. Honorable Speaker, to save the members from themselves reading the objects and the reasoning, I wish to read the objects and reasons of this bill. This bill is the first attempt at undertaking a comprehensive review of the Criminal Procedure Code of the Gambia since the enactment in 1933. The bill seeks to align our Criminal Procedure Code with current trends and practices including provisions relating to probation, parole, plea agreements, police supervision on convicts, alternative sentencing, the trial of corporate bodies, private prosecutions, protection of witnesses and victims, etc. The bill also streamlines the exercise of the court's discretion in granting bail by providing clear guidelines in the administration of bail. The bill also seeks to reinforce the right to fair and speedy trial of the accused persons by specifying reasonable timelines which have to be adhered to by the prosecution and the courts. Mr. Speaker, this bill and the previous bill go side by side. The Criminal Procedure Code, the previous bill, is the substantive law, and the Criminal Procedure Code or the Criminal Procedure Bill that I am moving now is the procedural component of it. So the two go side by side, and I beg to move this House. Thank you.
Thank you, Honorable Minister. Any seconder? Honorable Member for Kiang Central.
Thank you very much, Honorable Speaker. I rise to second the motion and then briefly state that, Honorable Speaker, the bill before us is indeed intent. There is a great improvement if you compare to the current one that we have. The little that I read, although I could not complete reading, you will realize that significant improvements have been made in terms of the principal magistrate to visit the police station, and then also the assistant that need to be provided to the assistant to the principal, a magistrate or a police officer. I therefore appeal that this Honorable House will be given enough time to go into detail of this important document that is very detailed, and then it needs proper scrutiny. Honorable Speaker, on that note, with those few remarks, I beg to take my seat.
We've not opened the floor yet. Thank you, Honorable Member. He only seconded the motion, the bill rather. In accordance with Section 67(1) of the Standing Order, I will now open the floor for the debate on general merit and principle of the bill. Any honorable member who wishes to partake in the bill may do so by raising your constituency card. Take note. You're taking note of that. Okay. Starting with Woolly East.
Okay. Thank you very much, Honorable Speaker. Honorable Speaker, the bill that is before us is Criminal Procedure Bill. I'm inclined to believe that the most appropriate caption would be Criminal Procedure and Investigations Bill. That is my thinking, because, Honorable Speaker, investigation and criminal prosecution goes together. And I believe the biggest deficit in our procedure is the side of investigation. We have a lot of problems regarding investigation. Apart from that, Honorable Speaker, I think it is timely that we have a review of the procedure code, just like the Criminal Offences Bill. One area I believe we must look at closely is the area of people with unsound mind. That area needs to be looked at very, very, very closely, Because, Honorable Speaker, many a time, people with unsound mind would be moving about, sometimes handling very dangerous weapons on the streets. I don't know in law, but I know in practice, the police seem not to care. And some of the time, these people will be threatening people with weapons, even in public. So I believe that the police need to be empowered to take action and take those people to the right place for treatment, rather than leaving them to go about their business in terms of threatening people to the extent of even killing people. We have experiences in my constituency. This person of unsound mind kept on threatening, but it appears nobody cares. They always think that he is just talking. But in the end, he carried out the act and killed the breadwinner of the family. And this is not once, twice, or three times. So I think that is an area that we need to look at very, very, very closely. Honorable Speaker, on speedy and fair trial, I think this is also another area which is important in the criminal justice system that requires urgent review. Honorable Speaker, a young man was sentenced to 6 months in prison by a district tribunal relating to the issue of compounds, ownership of compound. And after his incarceration, the wife complained to the courts as well as to the Human Rights Commission. But before anything could be done, the young man completed his sentence, even though he has made an appeal at the court. Because of the slowness of the process, the person carried out his sentence until he's done with the sentence, without the court completing their work, without even sitting to consider the case. So I believe something needs to be done to ensure that we have speedy trial, and because lack of speedy trial also is like miscarriage of justice. It's like denying the person justice. So this new bill should be able to address that issue. Because I believe, Honorable Speaker, the objective of this bill should be to provide greater efficiency and fairness in the process of trial and to reduce delays in the criminal justice system generally. That is a big concern we need to look at. Also, Honorable Speaker, I've already done with that area. Yes. The objective of the bill, or the merit of this bill, will be to get rid of the archaic system of investigation. Sometimes the police, when I report a matter to the police about somebody, the process is they will arrest since I made the report about the person, they will arrest the person first. It could be that me, who is reporting to the police, I'm the very person who has violated the law. So the process of investigation, things must be investigated first before arrests are being done. But most of the time, they simply follow the reporter. Whatever the reporter tells them, they just jump up and carry out arrests. That's the practice. So the procedure here must be clear as to state exactly how this investigation should go, so that we train our law enforcement officers to be able to do investigation in the most appropriate manner. On that note, Honorable Speaker, Thank you for the time.
Thank you very much, Honorable Member for Woodley East. Honorable Member for Central Badibu, the floor is yours.
Thank you, Honorable Speaker. Honorable Speaker, I would like to give my support to the motion that is before us. Honorable Speaker, as the saying goes, justice delayed is justice denied. This bill is there to ensure that timely delivering of justice is done within the length and breadth of this country. Mr. Speaker, if you go to the bill, section 21, where you have human treatment of arrested person, this is in line with good practices or international practices. People who are under arrest or who are about to be arrested, they must be treated as human beings. Their fundamental rights should not be abused. The fundamental rights should be protected. They are unaccused. They are not found guilty until it's proven before the court. So the bill is there to protect our citizens. Madam Speaker, if you go to section 26 also of the bill, arrest by private person. This will promote security. It will make our citizens involved. The work is not only the police who should carry it, if I understand it very well. But I want the mover of the motion to throw more light into that. As I read it, I believe that it's there to promote collective responsibility in terms of, minimizing the magnitude of crimes that we have in our society. 27 also talks of arrest of suspect doing damage to public property. Our public properties need to be protected. So sometimes we work in our society, people have this laissez-faire attitude.
Honourable Speaker, can I observe the Honourable Member for Central Badibu? Thank you, Honourable Speaker.
Honourable Member, do you give him he said observe?
Yeah, I think.
Give him the floor. Okay.
Yeah, I think we are dealing with the objects and the reasons, not particularly the build, the details of the builds in, I think.
Honourable Member, please. Honourable Member for Central Badibu, please go ahead.
Honourable Member, thank you for exposing yourself. I would like to continue. And if you look, I will not. If you look at section 32, where we have the principal magistrate to visit the police stations, I think where the suspects are kept need to be seen by the magistrate to go and see the conditions that they are in. So I think the whole essence of this particular clause is there to promote monitoring, to see what is happening in our police stations, to see how to deal with matters. So they are all, embedded to facilitate, fast or quick delivery of justice system. Mr. Speaker, if you go to subpart 4, prevention of offenses, prevention is better than cure. So I believe if you have this part in our criminal procedure, it will help us a lot in tackling, or in trying to minimize the rate of problems or crimes that are occurred in our society. Mr. Speaker, going to 39.2, security for keeping the peace. We all know that peace is universal, is a very expensive commodity, and we all need to nurture it. But sometimes, it's natural, peace becomes a rare commodity, and we sometimes find ourselves in a situation where peace is threatened with a lot of push and pull factors. So, but since we have this clause in our criminal procedure, it will help us a lot in keeping the peace that we all yearn for. Yes, the movement mention of this, the law been made since 1933, yes, and is subjected to, developments or approval. But the essence of it is all there to align our legal system, with the current happenings. So without having these criminal procedures in place, it will be very difficult to reach to where we want as far as judiciary is concerned or justice is concerned. Mr. Speaker, the powers given to the high courts also is well stated and is self-explanatory. I think, this will help our courts to deal with matters, effectively and efficiently. If you look at subpart 6 also, prevention action of the police, I think, Mr. Speaker, this point also is highly valued, and therein the police, the criminals, people who are accused of committing a crime, can be also pursued even in our local communities, in our local areas. And not only that, they can be easily transferred from one area to another area, which is also very good within the country. Like, for example, if you escape from an offense here, you go to URR or LRR, the courts there or the security officers there can really, pursue the person and bring him before the justice, before the law courts. Mr. Speaker, Part 4 also, provision relating to all criminal investigations or place of trial. I think this will help our police or our security agents or intelligence agents to be well equipped and well armed with knowledge how to investigate, rather than seeing things happening and you don't know how they happen. So the bill really will pave way for real change in our old or in the judicial system of this country. So, Mr. Speaker, I will not hesitate to give my full support to this bill. Thank you.
Thank you, Honorable Member. Honorable Member for Serakunda is the last on my list. If any honorable member want to participate, please.
Thank you very much, Honorable Speaker. Honorable Speaker, the two bills are interconnected and inseparable. You cannot charge a person of an offense without trying the person. So the Criminal Procedure Bill aims to address the issue of trial. But not only trial, but it's the issue of due process. How the arrest is done, all the way to the trial and eventual judgment. That is a process, Honorable Speaker. And essentially, it has been said, a law that cannot be enforced is no law. So if you have crimes stipulated, and you cannot arrest and try a person, then what we stipulated as crimes would be insignificant. Honorable Speaker, the whole process that is required in criminal procedure is to ensure that the liberty of the accused is not put at stake. The ordinary citizen is a free citizen with the right to freedom of movement, to liberty. And that should not be encroached upon unless the person is accused of something. And then that would subject the person now to some restrictions, but with presumption of innocence until the person is found to be guilty or otherwise. Honorable Speaker, it would be necessary to see how this bill protects the sovereign Gambian. And just by virtue of being accused, that person should not have that sovereignty abrogated. That the restrictions must be reasonable and justifiable in a democratic society. So essentially what we are looking at are procedures that we must weigh against those fundamental principles, that whatever restriction exists must be reasonable and justifiable in a democratic society. Whatever process in the courts a case takes must be reasonable and justifiable in a democratic society, so that ultimately, as rightly been quoted, that justice delayed, justice denied, that you will not have delay of justice. And you will not have a delay where the person will in fact serve imprisonment only to be found later to be innocent. So how do you ensure that bail conditions are reasonable and justifiable in a democratic society, and the conditions do not impinge on the sovereign right of the citizens? These are all issues that we need to look at as we move. Honorable Speaker, the issue of the text would be material in terms of what constitutions say about arrests. Do we need to detail the time frame, or do we just allow those things to remain in constitutions and be quoted in courts? Because essentially our law enforcement agents would have to be trained on the rules of procedure, because they are not only enforcing the law, sometimes they even serve as prosecutors. So how detailed should the law be? I think the drafters should be able to at least inform their minds on what the purpose of the law is, and how far should they go in terms of the details of making it time-bound, so that those who also read this, because in many instances, those who enforce the law do not look at constitutions. So if the Constitution says that within 3 hours you should be informed, within this you should see your counsel, within that this thing should happen. So if there are no details in the procedures and the law enforcement officers trained in them, usually they go unnoticed. So it is important that in terms of the objective of ensuring that the rights are protected, due process protected, then how detailed should the law be, I think, is a matter of concern. Honorable Speaker, looking at our own experience, we must say that this legislation is trying as much as possible to incorporate some of the progressive developments that have taken place. One is private prosecution. Here, I would want the Attorney General, the mover of the motion, to look at clause 86 and just for an explanatory memorandum on why that is the option. Because yes, the state is the key, but if it comes to a point where the state would ultimately have the full control to even stop and take over what will be private prosecution, I would want the Honorable Attorney General to really look into that and give some explanation in that regard. Or am I quoting yes, that's 86, because it states that the Director of Public Prosecution may, in respect of any private prosecution, apply by a motion to the court before which the private prosecution is pending to stop all further proceedings in the case in order that a prosecution for the offense in question may be instituted, or as the case may be, continued at the instance of the state, and the court shall make such an order. So is that not just completely negating the right to private prosecution? So these are issues. The object is to expand prosecution. Should the text, in fact, negate the object? This is really the issue there. So, Honorable Speaker, we will be looking at the clauses in detail and try as much as possible that the due process that we ought to protect is actually protected by legislation. That is what we are being asked to do. All the complaints we have, because here, Honorable Speaker, you will see where it says that you must have same-sex arrests, but then say, well, unless in some cases, so these are the exceptions that we should look at in legislation like this. That is, giving something in one instance and taking it away in another instance. So we have to have very strong justification for things of this nature, especially in terms of offenses that we are seeing against women. So how do you really protect women? Should you leave them in the hands of men who arrest them? And what should be the situation in police stations in terms of detention? So, Honorable Speaker, there are many other issues. And let me remark that community service is part of the punishment, but do we just limit it that low to certain areas, or could it be extended? I think the bar may be extended based on our debates and based on what could be achieved. So what offenses do you restrict from enjoying community service would be part of the debate that we may have at the committee stage. Thank you.
Thank you. May I now call on Honorable Member for Lower Nyomi. Lower Nyomi.
Honorable Speaker, thank you very much. I wish to join my colleagues in both observing and making statements regarding this bill that is presented to us. If bills are presented for amendments every 10 years, they would go to enhance the speed at which the people will come to understand the essence of certain laws that are passed. I would buy into a suggestion or an observation that was made by the member for Woodley East, that he would want to draw it a little longer to involve investigation. That investigation is key in almost all these activities that are going to lead to arrest, prosecution, and so forth. But I want to always be very cautious about laws that are made. Laws are mechanisms that are made to regulate the activities or the movements of society or people in societies. But how far do our people come to know about these laws? How far? What mechanisms are put in place to make sure our people know about these laws that they are arrested for, that they are convicted for, that they are sentenced for? How far? It's very convenient coming here making laws,
But it's another thing making sure the law reaches the people for whom it is intended. How far can we go to let these laws be known by the people for which it is crafted? How far? So that means there has to be a good lot of sensitization reaching out to people. What mechanisms would the Justice Ministry or other stakeholders do or make to make sure these laws reach the people for whom it is intended? It is not us at this level. It is not at the Attorney General's chambers. Even in the execution of some laws, some officers don't even understand. It's always a sad reality that we come as officers, we say we have arrested you. What evidence do they produce to arrest somebody? You just rose one morning, I suspect you. Let me search your place. These are laws that were there, and our people need to know this. Our people need to know this. With all the talks, with all the debates, if it does not serve the purpose of serving the interests of our people, we can just throw them back. It is for the benefit of our people that these laws are made. We're thinking here of 1933 laws to be amended, to be in concert with time. It is one thing for these laws to be amended, to be in concert with time, but another thing for our people to understand that these laws that are amended, these laws that are brought to be in concert with time, are laws that are known by our people. I am sure if you go to the street, make an assessment of a certain law, you will be faulty. You would have a lot of people failing to give you a good interpretation of what that law would mean. I would urge Ministry of Justice or the office of the Attorney General to see how much he can reach out to the people, to us, to make these laws known to all of us. I urge you and us to reach out to our people so that we would not be wasting time here only to draw a cupboard full of laws which we would not be able to interpret, understand, and then implement, execute. That is my take, Honorable Speaker.
Thank you, Honorable Member for Lower Newmy. Honorable Member for Basse, the floor is yours.
Mr. Speaker, thank you very much. Mr. Speaker, I equally join myself to colleagues who have spoken before me to recognize the efforts of the Ministry, the Minister, and the team of expertise. Honorable Speaker, I want to believe if we said ignorance of the law is not an excuse, if you leave me in my liberty and give me permission, I will amend this saying by saying ignorance of law enforcement is not an excuse. Because law enforcers in this country, many a time, do not know what they are doing. Members, be observant from today. What I'm saying is real. Themselves, who are enforcing the law, they don't even know the law that they are enforcing. So if you agree that ignorance of the law is not an excuse, equally agree that ignorance of law enforcement is not an excuse. That should be noted. And secondly, that will push me to say that before a critical activity, and I did remind you, and the Honorable Minister also did remind us that what I have said here, he confirmed that he is one who said it. Lawmakers, at the end of the day, you are responsible. Whatever happens, you will be responsible. The magistrate will not take part of any responsibility. If anything happens, they say it's your lawmakers. So the minister said this some years ago, and thank God, he is the one before us, bringing these laws. He wants to tell us, let us be very careful. Whatever we do here, tomorrow he will not stand responsible, but we are going to stand responsible. It's very, 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 very critical. And we need to be very careful in that. Communication is important. Laws are made in this country, but unfortunately, you can abide a law if you know it. If you don't know, what will happen? At the end of the day, 90% of arrests are innocent. They don't even know what they are arrested for. And unfortunately, the one arresting those ignorant is also ignorant of the reason why he's arresting that ignorant or that's innocent. You see the problem? And if you go that you are looking now for bail, conditions are put there. I will not go into detail, but one day I will come with reason, because I don't want to speak here without evidence in my hand. But what's happening in my region? One day I will come and tell you here. People are denied of their rights if you come to law enforcement. And we need to be very critical and very observant before such a situation. Very attentive. Honorable Speaker, I want to consult the Minister and the Ministry, having the belief that the Constitution is the supreme law. By my understanding, I stand to be corrected. I could be wrong. Any laws of this country, if it didn't conform with the Constitution, it's not a law. That's my understanding. If that's the case, I want to consult you on two things. One, in the Constitution, section 120, said the courts of the Gambia. And if you go to B, the magistrate courts, the Kadi court, district tribunals, and such lower courts and tribunals as may be established by an act of the National Assembly. So if I take you to the bill, on page 13, I will have a question to ask, or two questions to ask. The first question is interpretation of the word court. After interpreting, giving all the information about the word court, you have but does not include a district tribunal. In the Constitution, district tribunal is a court. But in the interpretation of court in this document, it is everything except district tribunal. I don't know, and I'm exposing my ignorance to get more understanding, so that tomorrow, if I'm informing my people, I will give them the clear information. And again, by defining the word courts, high court, a court of appeal, high court, we are also defined, they are captured as court. But if you go again down, you have court, mean the Supreme Court, court of appeal, high court, etc. Now come down, court of appeal, mean the court of appeal of the Gambia. What is the difference of this court of appeal of the Gambia and the court of appeal that you have defined under the interpretation of the word court? And you have similar of such in the document, I don't want to go into detail, but if I understand this first beginning, it will help me to understand the deeper information in the document. So, Honorable Speaker, with these notes, I thank you and beg to resume my seat.
Thank you very much, Honorable Member for Basse. It's the last on my list. May I now invite the Honorable Attorney General and Minister of Justice to respond to the issues and wind up the debate. Honorable Minister.
Thank you very much, Honorable Speaker. Thank you, Honorable Member for Kian. Is it Central for seconding the motion? Member for Woodley East proposed the change of name from criminal procedure to criminal procedure and investigation bill. Criminal investigation is part of criminal procedure. So that's the answer for you. So your concern is on board. Criminal investigation is part and parcel of criminal procedure. So when you say criminal procedure, you have catered for investigation. All right. I agree with you and many other speakers that the review is timely. And you aptly captured the objects, and I like the way you even looked beyond the objects as they are stated, that we're looking forward to greater efficiency of our criminal justice system and dealing with the delays and so on. Central Badibu requires me to shed light on private person arrest, or what in some jurisdiction they refer to as citizen arrest. This is it has been in the old one that we are amending. Probably we are just improving on it. I think, I don't want to say something I'm not sure, but I think even in the Constitution, citizens, probably I'm mixing between the CPC and the Constitution, but I know it exists somewhere. This is not entirely new in our laws, that people who are witnessing a commission of an offense before their eyes have some sort of right to effect arrest on suspects, and as soon as possible surrender them to the nearest police station, who will take over from that. So the private arrest that you are asking about covers that section. I apologize, I did not capture the section specifically, and I don't want to take time to try to skim through which section is dealing with that. But it is not new in our laws, and it is progressive, because it's not at all times when crimes are being committed, law enforcement officers are present. So do we give a blind eye to commission of offenses where even we can intervene and make a difference? So it's really inviting citizens and even residents of the country who are not necessarily citizens, not only to be law-abiding, but to complement law enforcement by themselves being watchdogs around their communities. We are aware of these concepts of community policing and all whatnot. It is regulated. It will be regulated. It will prescribe how it can be done, and immediately an arrest is effected, what steps needs to be taken as soon as possible. Yes, the requirement on principal magistrate visiting police stations within their jurisdiction, or the most senior magistrate where there is no principal magistrate, is a novelty. It has not been there before, and it's very encouraging, because it is meant to discourage extrajudicial detentions. So people who are kept in police stations are meant to be kept for a specific period of time before arraignment. At times, sometimes people tend to be kept a little bit beyond the permissible period for the law enforcement to keep them. So if you have a magistrate that is under an obligation to periodically visit the police station, probably that will be a watch over the police and other security apparatus to make sure people are arraigned as quickly as possible. If they have to be detained beyond the stipulated law enforcement power of detention, it has to be a judicial detention. It is the court now that have to determine whether there is sufficient reasons to keep them or they ought to be released conditionally or unconditionally. Member for Serekunda Kading Agrimo emphasized the importance of this bill as to guarantee due process, and that due process to be mindful of the presumption of innocence guaranteed in this constitution, and I'm sure in any other constitution. The principle of innocence is universal. It's always have to be guaranteed. The member seeks some explanation with respect to Section 86, which deals with the issue of, Director of Public Prosecution to intervene in private prosecution. No, it is not. This is not one of those clawback clauses that you are concerned about. It's not completely taking out prosecution. The Director of Public Prosecution would not have a right to terminate private prosecution completely. He can only take over and continue the prosecution. So if you look at the text again, I'm sure you will see it, is to take over with the view to either changing the forum, probably taking it from one court to another court, or if it is going to continue in the same forum, for the director himself to continue the prosecution, right? This, because irrespective of who initiated the trial, any criminal trial is for the public good, and the state has an interest in every single criminal trial. So for whatever reason, for example, if the prosecution, Director of Public Prosecution, either because they are not aware or they have been notified they did not take any step, maybe they don't believe an offense was committed, or for whatever motivation they fail to take their rightful role to prosecute, a private citizen decides to initiate prosecution. The Public Prosecution Directorate cannot discontinue, but they can take over and continue. So the taking over here under Section 86 is not to discontinue, but to take over and continue, either in the same forum, or you can change the forum to another court and continue the prosecution. So I hope that will allay your fears, because if it were to take over and discontinue, then that would defeat the purpose of private citizens being allowed to initiate private prosecution. I agree with you, and I think we will look deeper into the issue of women's rights vis-a-vis criminal law enforcement. You raise salient issues there, and I'm sure the technicians are taking note, and when we come to committee level, if not adequately catered for, we'll see what we can do with respect to that. I can, on top of my head, remember a lot of practical problems with respect to how we enforce our penal codes with respect to women. I remember one incident where I was conducting training for law enforcement officers several years ago in the provinces, and the issue of search came. How do you search a female suspect? The law is the body of the female suspect has to only be searched by a female officer. And now I think we are better off. There are a lot of female law enforcement officers. In those days I'm talking about, you can pass several police stations in the provinces without a single female officer. So I remember one senior officer told me, well, we improvise. I say, how do you improvise? He said, we use our wives to search them. All right, and that raises several issues. Is the wife the competent person to perform a search on somebody? And what do you do? But you raise another issue. How do you even detain them? If you have only a single cell in a police station, and now you have female detainees and male detainees and so on and so forth. These are important things that would have to be looked at carefully as we move on. Member for Lower Nyomi, I cannot agree more that for laws, 10 years is a reasonable time that we could review them periodically Of course, yes, after a decade. If there is a need to change anything, we change. If there is no need, we move on. But I agree with you, periodically legislations need to be reviewed in that regard. But you express agreement with Woolly East that investigations should be included. Investigation is already part and parcel of this bill. You mentioned mechanisms to put in place to make our people know about. Okay, this is a recurring statement. Is coming as a concern of everybody. And of course, I understand it should be a concern to you. You are the people, representative of the people. This is one area that I spent most of my service in government, most of you would know, trying to raise awareness of the citizenry on their on laws generally, but mainly on their civic rights, duties, and responsibilities. This is a duty of everybody. I agree, Ministry of Justice will play our role. The National Assembly have a role to play. There are some institutions that have been created purposely to carry out this kind of task as well. I don't know to what extent, as a National Assembly, you are empowering them. I'm not advocating for anybody or for any budget support, but I'm just thinking critically that there are national institutions set up for this. Civil society have a role to play. National Assembly, yourselves, you have a role to play. At our level, Ministry of Justice, we will do what we can. But of course, yes, when we make laws, particularly laws that govern the conduct of people in society, they have every right to know those laws. Even though we agree ignorance of the law is not an excuse. But I said it here, I think, last week. Quite a number of people in society would not have committed offenses if they knew their actions would constitute an offense. Right? Some people commit offenses because they did not know that that action is an offense. Right? So, unfortunately, the ignorance of the law would not exonerate them when they are charged and brought before the law. But we see these things as a sitting magistrate. You see people being brought before you at the time when I was, and you are convinced that probably they did not know what they did was wrong at the time they were doing it. But your hands are tied. The principle remains the same. I don't know is not a defense. Right? So how do we circumvent that? Is all of us have to invest our time, energy, and resources in helping our people. In any small way that you can. You can talk to your electorates, the very little meetings that you have with them. You can talk to them about the little thing you know about the law. Probably you have a checklist of some of the important legislations you have passed during any session. Maybe when you go back to your constituencies, that little effort, you may not know, but can make a lot of difference. We will do ours, other agencies will do, but nobody can downplay the importance of bringing these laws closer to the people. It can save a lot. There are so many members of society who voluntarily can comply with law. They as long as they know something is illegal, they wouldn't do it. They wouldn't ordinarily do it. But the principle remains the same. So how do we want to avoid people falling foul of the law purely based on ignorance? Is to enlighten them. And that, yes, some institutions have responsibility, but let's see it as a collective responsibility. And we do our little in that regard. Probably we can make changes. So we take the challenge. You urge us to spend time, and we will, but we can all make a difference. Basse, ignorance of the law enforcement is not an excuse. This principle of ignorance of the law is not an excuse applies to even law enforcement officers. So in the process of enforcing the law, if they break the law, their ignorance of that law will not excuse them. So it's a principle that cuts across. All right? So be rest assured of that. Unfortunately, if they break the law and they are not caught on the act or nobody complained against them, then that is difficult. But probably when we enlighten our people that even those who enforce the law themselves are subject to law, and probably that will tighten the knit a little bit on them, and they will try to do the right thing. Of course, I agree with you, it's not an excuse. In fact, the law enforcement officer should know the law better than the person on whom the law is being enforced. Okay? But the principle applies to themselves as well. So in the process of enforcement, if they break the law, they are not going to be excused by saying they don't know. In fact, they're the first people that ought to have known. You've raised something that is triggering my thinking deeply with respect to this definition that you raised, that Section 120 of the Constitution defines the district tribunal as a court. The Criminal Procedure Bill excluded it as a court. We will look into that. The answer that comes on top of my head is the Criminal Procedure Bill is a specific legislation for a specific purpose. So it's defining courts with respect to criminal offenses. Okay? So, because previously, I think the District Tribunal Act itself is one act probably we'll consider. It is also a 1933 or around that area law. It's very old. They have wide-ranging criminal jurisdiction, which we are trying to work on, whether we should leave that with the district tribunals. Do they have the capacity to prosecute those offenses? So probably the thinking is gradually we might leave them to administer customary law as they do and probably limit them to that. They are not actually even enforcing the criminal code as much now. Usually when it comes before them, they refer it to the police. But the fact is, it's still in their mandate. So something will be done about that, I can assure you. But the intention here probably is to remove criminal jurisdiction from them. But I'm thinking aloud, like I said, when we get to the technical level, we look into the details, because removing the subject matter jurisdiction from them, like criminal issues, which is a subject matter jurisdiction, from them does not change the fact that they're still a court. So I will look at this issue you raised. It's critical. I will look at it. I cannot give a straightforward answer, but I commend you for that observation, and the technicians will look at it closely. Unless there is another issue, Honorable Speaker, these answers form part of my responses to the issues that has been raised. Thank you very much.
Thank you, Honorable Minister. Honorable members, in accordance with Clause 68(1) in bracket of the Standing Order, the bill is hereby referred to the Assembly Business Committee Honorable members, it has been moved and seconded that the bill entitled to Criminal Procedure Bill 2020 be read second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
The Criminal Procedure Bill 2020 is hereby read a second time.
Thank you, Clerk. Honorable members, in accordance with Clause 68(1) in bracket of the Standing Order, the bill is hereby referred to the Assembly Business Committee for committal to either the committee or committee of the whole House. Yeah. On that note, I now put the question: be it resolved that this August Assembly do stand adjourned until Tuesday, 14th July 2020 at 10 a.m. Those in favor, those in favor, please say aye.
Before you go.
Hello. Yes.
Yeah, just an observation, Honorable Speaker. Honorable Speaker, the National Assembly did commit the Women Enterprise, the Gambia Women Enterprise Fund Bill 2020 to a joint committee with the mandate that the committee should report to this Assembly today. Honorable Speaker, under normal circumstances, I should have moved a motion for an extension, but that will not be in line with our standing orders, which gives all committees 16 weeks to preside over a matter. It reads, for a bill committed to a select, standing or special select committee, that is standing order 66, paragraph 2A, it said that for a bill committed to a select, standing or special select committee, a committee stage shall commence on the day after the bill stands committed to a committee and shall end no later than 16 weeks thereafter. And subparagraph 4 is saying, before the conclusion of the period specified in paragraph 2A, a motion without notice may be moved in the Assembly by the chairperson of the committee to extend the period until a date specified in the motion. Honorable Speaker, the fact that what is stipulated is 16 weeks, there would be no need. I think the Assembly wanted to speed up the process, but it is important to inform you that the matter is not in the hands of the committee, it's in the hands of the mover. We have examined everything, and the mover believes that we should give them time to consider all the proposals made, and they will come back to us. So we cannot really give you any date until we hear from the mover. This is just an update to the Assembly.
Noted. On that note, I now put the question. Be it resolved that this August Assembly do stand adjourned until Tuesday, 14th July 2020 at 10 a.m. prompt. Those in favor said aye. Those not in favor said no. Ayes have it. This Assembly now stand adjourned until Tuesday, 14th July 2020 at 10 a.m. prompt. Thank you. Assembly now stands adjourned. Honorable Minister, you may leave. Thank you.
yara nyilla domoro kadiyata
boy janno sikes restaurant
e sai nakko be ninna dimbal nimba domoro kala janno
domoro seneyata adiyata topotoro fanan kendema bije luntan during tamala abeka domoro ki janni adi manda wala de teka we bijele anim fanan ka fadi jang ikono e fa e ka fa minne ko pastry anim bakery iko fanan be kalele badde lomba conference lomba workshop lomba ye fo fendin lon dunia kono domoro betama nyillom international o tewoda number 1
amanke ba domola jandama
e sa domo jang is atariya
wo mu kubandi
sa nakko sa futandin
e oto sa nakko be mu sikes restaurant
ndabana janna mu yat ni manje dorom bijam
aban
CK's Restaurant, known for best quality food and customer satisfaction.
diwli lanni maaro lanni
fop lanni
awa joni mi anda honno gerdeten e ngal ɗo sabu e ngal ɗo Ibrahima jonnal taw joni mi anda se yahay kapitiki ñawloɗen ha humpodire makko est ce que noon e warude
waɗen noon awa
ane ko de Ibrahima ma ko to woni
mo Amérique
ko Amérique a woni kede humpitaki fiɓe musidɓe men baluwo
baluwo
ɓe andanɗa kala ko wawɗa wonde e aduna o si a rewi e juuɗe maɓɓe a jonnay ɗo dépensement o Gambia hara no weeɓi a yahata kadi taw ko mbuɗi ɗi no ƴawi walla no jippi ɓe haalantama ko kala ko falɗa ko sengo ñamete ili nebba maaro basalle pomme de terre kala ko rewi ɗon a hendoto hara no weeɓi kadi wona ɗum ɗon tu ɓe aɓe jonnira e mobile phone siko ɗum kadi laptop kala ko wayrode ɗiɓe hay kaspawa ɓe wawma jonnude kadi sa fala humpitade ko weeɓi ƴettu Google account ma joni data ton waɗa download app maɓɓe on ayiyay kala ko humpima e maɓɓe ton ɓe weeɓiyama
ka wonɗa wo e aduna on
kala ko wawɗa
a jonnanayi wonɗo ka leydi men Gambia ɗo dépense
hara no weeɓi ha ma si ɗum non fof no neeɓi immoɗen joni mi ɗowtama ka place maɓɓe jano
waɗen joni
iya heɓa ko falata
waɗen kisam
When we touch down, better broke down.
With Gamtel G-Fiber, now you can enjoy super fast internet in gigabytes. G-Fiber is affordable, stable, secured, and accessible to homes, businesses, and enterprises. With Gamtel G-Fiber, the future is speed. Gamtel, creating a brighter future in communication.
That's how she became mine and see that.